Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled Maritime Law, Differences Between Land Registration and Ship Registration. So this is the fifth part of the video. The Dutch sea power and maritime skills were held in very high esteem all over Europe, so much so that even in Russian Tsar Peter the Great spent several months in 1697 and 1698 in Zaandam and Amsterdam to learn to build ships and to get acquainted with all aspects of life in the Dutch Republic. Improve unextended port infrastructure, increasing export traffic of industrial products from Wallonia and Germany, export of raw materials from abroad, inter alia, crude oil from the US and the Russian Black Sea port of Batum, and from Kingway Port, Congo, Ivory, rubber, palm oil, copper, and iron or diamond. Perfect inland locations at a distance of 80 kilometers from the North Sea and nearby the Wallon and Root steel mills. The availability of railroads and inland waterway and other factors explain why Antwerp became the first world port by 1870. A great deal of money generated by the sea trade found its way into art collections, beautiful art deco, buildings, and scientific enterprises such as the famous Antarctic expedition, the Adriatic Galaxy, the Gamari undertook from 1897 till 1899. And last but not least, it was in Antwerp that, on the initiative of the Belgian politicians Auguste Bernard, the Belgian maritime lawyers Louis Frag, and the marine insurance broker Charles Lejeune, the Comité Maritime International or CMI was founded in 1897. This committee was instrumental in promoting and advancing the cause of the unification of maritime law, the international relevance and peculiarities of maritime law. Persian law. Unlike civil law, maritime law was not imposed by legislating authorities top-down process, but was mainly created by merchants and seafarers bottom-up process. It is part of the famous Lex Mercatoria, which is the customary law, meeting the needs of trade and shipping. As time went by, the most important principles of this customary law were laid down and ratified in written codification. The most famous of these codifications are the Lex Rode de Jactu incorporated in the Justinian Codex Juris Civilis, Byzantine Empire, the Tabulae Amalfitanae for the Amati Republic, the Libre del Consolat del Mar from medieval Barcelona, the Rose de Oleron attributed to Eleanor of Aquitaine, the Judgment of Dame, the France 1891, Ordonnance de la Marine, and the maritime law provisions contained in the French Code de Commerce, promulgated in 1807 by Napoleon. International law. International law is international by its very nature, and its shipping and navigation span the globe. Maritime law can truly be called global, as the high seas were considered the res communis or common property to all and are free to be used by the all nations for seafaring purposes. It became necessary to try and create some kind of international framework of common rules governing all things maritime. The first effective step towards this international codification were taken by the Antwerp Maritime Community, who created in the Comité Maritime International or CMI in 1897. The CMI created and helped create many important international maritime conventions. Other important international maritime conventions were concluded at the initiative of the UNO or the UNO specialized organizations, namely the International Maritime Organization or IMO and the United Nations Conference on Trade and Development or UNCTAD. One who is familiar with the maritime law cannot help but feel bewildered by the little progress made in the field of European, let alone international, harmonizations of civil war, civil law, and for that matter of land, mortgage, and registration law. It is worth noting that many international maritime rules and conventions came into existence in reactions to disasters. So this is what the ancient Greeks called learning through suffering. Two examples may suffice. On April 14, 1912, the Titanic sank after colliding with an iceberg. The disaster led to the adoption of the first international conventions for the safety of life at sea, or SOLAS, in 1914. More than 1,500 passengers and crew died, and the disaster raised so many questions about the safety standard enforced there. The United Kingdom government proposed a conference to develop international regulations. The conference, which was attended by representatives of 13 countries, introduced new international requirements dealing with the safety of navigation for all merchant ships. Later on, the SOLAS conventions was regularly updated and amended. The last version was adopted in 1974. In 1967, the Torrey Canyon ran aground while entering the English Channel and split a cargo of 120,000 tons of crude oil into the sea. These accidents raised questions about measures to be taken to prevent other cases of oil pollution from ships and to provide a more adequate system of compensation following accident at sea. This eventually led to adoptions of the International Conventions for the Prevention of Pollution from Ships, MARPOL, in 1973, in the wake of subsequent oil pollution accident. Further amendment and protocols, the MARPOL Conventions, and additional measures were taken. Perils of the sea. At the heart of maritime laws lay the notions of perils of the sea. The notion refers to the specific type of the natural accident peculiar to the sea. It can be maritime accident and dangers such as the storm, waves, wind, collision, or the vessel fire. Smoke and noxious fumes, sinking, flooding, and capsizing, loss of propulsion or steering, and any other hazard resulting from the unique environment on the sea. They also include accidents caused as a result of stacking, striking a submerged object, or encountering heavy weather or other casual forces of nature. So the time is up and the article will be continued to read on the next video. So bye bye. And don't forget to like, comment, and subscribe. Bye!